The Supreme Court sidesteps all pending gun cases, plus the limited effect of Chevron on firearms litigation. All this and more on the news update.
No, the devil's got no hold on me.
All right, ladies and gentlemen, welcome to the news update brought to you by TheReload.com. I'm contributing writer Jake Fogleman, joined as always by Reload founder Stephen Gutowski. TheReload.com, of course, is where you can head on over and sign up for our free weekly newsletter to keep you up to date on all things happening in gun policy and politics. This week, some of the big news we want to talk about is once again the Supreme Court. Not because of any big major case decision, those are all done for the term, but because they issued their final orders list of the term before they go on what's called summer recess. And it was not the best news if you're someone that was interested in them taking another big Second Amendment case next year. They essentially cleared their plate of all of the pending cert petitions and sent a lot back to the lower courts. And they also completely denied taking up an assault weapon ban case. So interesting result.
Yeah. Before the summer vacation that the Supreme Court still takes for summer, it feels like an archaic thing, right? Like
a little bit, yeah.
They're not school children, and we have air conditioning now, so it feels like a holdover from, that's what summer vacation kind of is, right? Holdover from before air conditioning was around, and so it's too hot to go to school in the summers and too hot to do court work. But it is 2024, and they have put air conditioning in the Supreme Court. So I don't know why we still give the justices a bunch of time off for no, especially with how slow they've become over the years. This court in particular just doesn't like to do a lot of cases. So maybe they should rethink that. I don't know. I'm not a Supreme Court expert on the process side, so maybe it's built into the Constitution or federal law somewhere that they have to do this. I have no idea, but it just feels a bit odd that, like, they're grown adults. Why are they getting summer break? And I think if they're going to have a summer break, they should do like kids do and get summer jobs at the grocery store or the pool or something.
Wouldn't that be a sight?
I don't know. Maybe they'll help them reconnect with real Americans in that way. But regardless, yeah, it's not a positive outcome, I think, for gun rights advocates or for the Department of Justice, frankly, right? The DOJ specifically wanted them to take like 6 cases. And they said, hey, no, we're not going to do any of that. They have kept these cases alive, right? Because they technically did take some, right? They granted, vacated, and remanded several, including the Antioch case, the Sensitive Places case in New York, and then some of these felon in possession cases like Range, right? And then even the Illinois assault weapons ban cases, it's not a final judgment, and that, in the sense that the case isn't at final judgment, and that's seems to be why they denied cert. At least that's what Thomas said, and we'll get into a little bit more about what he said because you've got an analysis piece on that coming soon at the Reload. But so it's none of this is like, oh, we're never going to hear these cases. It's more like we're not hearing them right now.
Right. Yeah, it was almost like a kick the can down the road a little bit kind of a thing, because inevitably a lot of these are going to come right back to the Supreme Court. I'm thinking in particular these felon in possession ban cases. I mean, there's a reason DOJ wrote that letter after Rahimi was decided saying, hey, great, I'm glad you guys decided Rahimi. I'm glad you decided in our favor, but you didn't really give us much help on these felon in possession ban cases. And those are 12% of our federal prosecutions. So it'd be great if you could quickly take these and please don't GVR them. And the Supreme Court said, well, we're going to GVR them anyway. And good luck. So I think they're coming right back at some point. I think it's safe to say.
Honestly, I wouldn't even expect them to change at all. They GVR'd these cases, but it's hard to imagine with what happened in Rahimi, any of them being like, I just don't see any of these lower courts looking at Rahimi, looking at how they decided those cases and saying, oh yeah, we're totally going to change anything about what we did. Certainly there is the potential that maybe a case like Range that went against the government could go the other way. I don't think it will, but Rahimi, basically what it did is smack down the Fifth Circuit for being too strict about how it applied Bruin. And so maybe some of these lower courts that, like in Range, that struck down the charges against this guy, the Pennsylvania man who had lied about his income to get food stamps and has been a felon under the federal felon in possession law ever since then. Maybe they come back and take a more expansive view of what historical principles are involved in the case. I just kind of doubt it, though, because I just don't see a ton of overlap. Certainly the narrow holding of Rahimi wouldn't affect Range, because Range wasn't found to be dangerous, and his gun prohibition is permanent, not temporary. Right. So it certainly doesn't seem to have any direct effect there. And same for like Antioch, the sensitive places case. I don't see how you get from the narrow holding to overturning the New York Circuit's decision, especially because the court was saying that the Fifth Circuit was too strict in how they interpreted that. That wouldn't necessarily undermine how the New York Circuit decided Antioch. So it just feels like they're going to go back down, and then they're going to come back up with the exact same decisions.
Yeah, right? I think that's my thought as well. Maybe they're doing this just to, they like to procedurally let things percolate, properly, go through the proper channels.
But I just don't. Like it's stalling tactic.
Yeah, it just does not seem like anything is going to change in, frankly, any of these cases because of what you just articulated.
Yeah, I mean, technically, they've ruled something. They interpreted the Bruin test, and it's the first time they've done it. So it's. I don't want to underplay the importance of it, but I don't know that I see anything in Rahimi that's going to make any of these lower courts question how they got to the conclusions they did. Right. Even if they got to wildly different conclusions from a different circuit court. Right.
Right. Yeah. But, I think it's noteworthy you're seeing people on both sides of the fence say that same thing. It's sort of atypical when both sides on either side of the issue agree, like, hey, you didn't give us much guidance, so I don't know what you expect from us here. So I think, quite frankly, this will be back fairly shortly. Now, the assault weapon one is a little bit of a different story because, as you pointed out, it wasn't GVR'd. It was just completely denied because they seem to articulate because it's in what they call an interlocutory posture.
Interlocutory? Right?
Yeah, interlocutory. Yeah. Essentially,
at least this is what Thomas said. We don't have anything from the majority of the court. We just have we got two pieces of information. Right, Alito would have granted it immediately. Yeah, at the stage it's at, which is it's only at a preliminary injunction stage. Right, so that's what they mean. Like it hasn't gone to final judgment in the lower court yet, but the gun rights plaintiffs wanted a preliminary injunction. The lower courts have denied that, and so they wanted the Supreme Court to step in and give them one. And the court's saying, no, but we have two pieces of information. Alito would have granted the case. Thomas wrote a whole statement about what his thoughts on it were, which is what your analysis piece gets into, right?
Yeah, that's right. So Alito would have granted cert. Thomas doesn't seem like he was going to grant cert, but he made it very clear that he's super interested in the issue anyway. He essentially said, I respect that this court wants to wait for things to go to final judgment. I totally get that. However, and then he goes through this sort of long soliloquy about how we've never really fully addressed what type of arms are protected under the Second Amendment, which is something we've talked about pretty extensively on this, at the Reload and on this show.
Yeah, at least not beyond handguns, right?
Right. And that's what he says. He's like, since Heller, we haven't really touched the issue. Meanwhile, all these cases and controversies keep happening with different courts, in the Seventh Circuit, which is what they were dealing with in these Illinois cases, said AR-15s don't even count as arms under the Second Amendment. It wasn't even that there was historical analogs. It was just that, quite frankly, the plain text doesn't even cover them. And he kind of unsparingly criticized that and said, that's he called it unserious at one point. He used several adjectives, basically, in so many words, saying the Seventh Circuit's wrong, and if this was before me, I would reverse it. So that's a big piece of information right there.
He was pretty straightforward that he thinks the Seventh Circuit is wrong and that these bans are unconstitutional. He might have couched it very slightly, but for the most part, he's just kind of comes out and says, these kinds of bans are not in line with the Second Amendment, and. So I honestly feel like while he was saying he understood why the court might not take it at this point, that kind of feels like a tactical thing for him to say. Now, this is a lot of when it comes to the Supreme Court and we're talking about tea leaf reading like this. All we know is Alito would have taken it and Thomas wrote this statement. We don't know anything beyond that. The rest is just speculation. But to me, it feels like Thomas is saying this as a nod to, they couldn't get 4 votes to take this case because that's what they need at this stage. But I think Thomas feels that there are probably 5 or more votes to overturn this ruling once it gets to final judgment. And so instead of trying to push the issue and alienate the other conservative justices, because after the way that these last couple of cases gone, it's pretty clear that none of the liberal justices are going to be on their side in a case overturning an AR-15 ban. But I think he didn't want to alienate the rest of the conservative justices. And so he's saying, oh, yeah, I understand we're not going to take it right now, but we should take it once we get a final judgment opportunity.
Right.
And honestly, it's probably not going to be those Illinois cases. There's probably going to be maybe the Maryland case or a California case that's going to get to them after final judgment before the Illinois case does, especially because, and after a statement like this, like all the lower courts that want to uphold these bans understand that it's a big risk for one of them to get to the Supreme Court. Now, there's only so much they can do in delaying things, but they can delay things, right? And that's where, that Illinois case, I would expect that the process to be drug out, frankly. And I'd expect any court that doesn't want to see an AR-15 ban struck down by the Supreme Court is probably going to take as long as they reasonably can to issue their final judgments in these cases. We saw this in the Fourth Circuit, right?
I was going to say,
with the Maryland case. Right?
You've already seen it play out where they'll put all these procedural games and unprecedented moves to take something en banc before the 3-judge panel even issues its decision, after the 3-judge panel sat on it for a full year after oral arguments. So it's all these delay tactics where I don't know if they're hoping to play the actuarial game or what, but they clearly are trying to slow walk this sort of stuff. But I do think it's noteworthy, just Thomas issuing this statement in some ways puts those lower courts on notice to a degree, right? It almost has the same effect as a GVR because it's essentially saying, hey, I'm keeping my eye on these cases and the court is too. So whatever you do, very heavily implying the way you're doing text history and tradition about AR-15 bans is incorrect. And I think we're going to take it if you keep doing that. There's something to be said for that as well. I'm not sure that changes what the 9th and the 4th and the 7th Circuit eventually does, but I still think there is something to that where he's essentially putting them on notice that, hey, you're doing it wrong and we're going to correct it if necessary.
Yeah. Although there's 2 caveats I would add to this, right? One is, they did the same thing in Antioch in the sensitive places cases out of New York, the Second Circuit, right? Where they said, we don't want to take this right now because it's not a final judgment yet. But and I think in that case, it was Alito, right?
Yeah.
But we think that in that case, the district court had struck down most of the sensitive places restrictions that New York enacted. And Alito implied that ruling was right. And that if the Second Circuit didn't move fast enough, that the plaintiff should come back and seek, further action from the Supreme Court. And what just happened in that case?
Right. That's a fair point. Yeah, that's a fair point.
I don't know. And look, this is something that we always talk about as well. The court's timeline is very different from regular people's time, a watcher's timeline, our timeline. Probably our audience's timeline. Like people think, oh man, it's taking a year or 2 years for the Supreme Court to act or 3 years to act on these things. That means they don't care about it and they're moving really slow. In court time, that's pretty fast. So just because they GVR'd Antioch and sent it back down and they didn't take the fastest possible option in the Illinois assault weapons ban case, that doesn't mean necessarily that they won't eventually get to that. And that they won't eventually strike down. I mean, if you had to bet on it, they probably will. Although the other caveat that I would say is the Thomas statement in those Illinois AR-15 ban cases does remind me a bit of the Thomas statement or dissent in the California concealed carry case from a couple years back, several years before Bruin, right? There was a whole slate of Second Amendment cases for the court laid out for the court to take up, and they denied all of them. Similar to this, not quite the same. They just denied cert in all of them. That wasn't GVRing involved. But one of those cases was a case very similar to what Bruin ended up being, but in California. And Thomas wrote a dissent joined by Gorsuch. And that's where some of the, he talked like he often does about second class rights. By the way, I love that he ended I like when Supreme Court justices do this. He ended his statement from this week with a quote of himself saying this line about the Second Amendment being a second class right, or the risks of it becoming a second class right. And I think it's sort of like Eminem's new song. He samples himself, right? It's sort of the Supreme Court equivalent of doing that. And I think they all kind of do that to some degree. I think Thomas is particularly a fan of quoting himself from other things he's written. But yeah, so in that case, in the California concealed carry case, you had Thomas write this dissent joined by Gorsuch, and similar to what's happened with Alito and Thomas here. And I think they were more writing from a position of weakness where they couldn't take these cases. They weren't confident they were going to win. And I don't know. So, there's some parallel to that as well going on here. It's not entirely clear where the court is going to fall on these things. It's sort of, with 6 conservative justices, you'd think you would know. But, Rahimi was 8-1 with Thomas, flaming the whole thing as basically abandoning the Bruin test and coming up with a new, weaker test that risks undermining the Second Amendment altogether. So I don't know how influential his voice is on this issue within the conservative caucus of the Supreme Court is certainly up for debate at this point. Yeah. So I don't know.
I think it remains to be seen that I think the California example is 2017, the case Peruta. I think it's an interesting sort of case study in how this could work, because it could just be that the court is just going to wait for the right case at the right time, because Thomas in that case ended up just being a couple years early, because in Bruin, they essentially
5 years though. That was 5 years before they got to Bruin.
And so I think that would disappoint gun rights advocates if that was the same sort of timeline for this issue. But at the same time, like you said, court years are different than. Yeah,
they did eventually get to it. Yeah, sure.
Yeah. So
he did end up on the majority side once they did get to it.
Yeah. So we'll see. We'll certainly stay on top of what they end up doing with these hardware ban cases, because, like you said, Illinois, that's not the only assault weapon ban case sort of percolating its way up the appellate court system. And we'll see how eager they are in the future to take some of these cases.
Yeah. And I think those cases are the kind that would make that sort of anti-Rahimi case that we talked about last week.
Right.
When I wrote my analysis piece on Rahimi, where it's like, here's the court saying you're doing Bruin too strict. It would behoove them perhaps to then do a case where the lower court has done it too loosely. And I think a lot of these hardware ban cases probably fit that mold more than like Range does, because Range, the lower court, they didn't do the test loosely. They struck down at least the law as applied to Range. And so you really need, I think, is more of a case where the lower court did the Bruin test wrong, so in the other direction, so the court can kind of start to try and funnel things into where they actually want them to be. And that's one path they could take to doing that, but we'll see. Yeah. And also I should mention too, that the interview podcast this week, which is, obviously we're doing things a little bit shortened here for the holiday weekend, so everyone can enjoy their holiday, and you don't have to worry about waiting for the podcast to come out or whatever. But we've got the interview podcasts featuring Pepperdine University's Jake Charles, who is been a prominent Bruin critic, and his reaction to the Rahimi case. So we had, Dave Kopel, who's a big gun rights scholar who wrote a brief that was influential in the Rahimi case. We had him on 2 weeks ago to give his reaction. And now we're getting someone from a different perspective to give his. So, make sure you guys check that out once it's out on Sunday for members, of course, as always, and then Monday for everybody else.
Moving on to one of the other stories we have this week, it's related to the Supreme Court, but not a gun case, but potentially some gun implications. It's a guest post from Matt. We always struggle with his last name, Matt LaRosiera.
LaRose. I mean, yeah, he was on the show and I did this and I've already forgotten how to properly pronounce it. But he's a gun rights litigator out of Florida who has, handled real world gun rights cases that makes him, I think, a particularly good source of analysis on this point that he wrote for us on essentially Chevron, right? Like his pieces. Yeah. This is something that's been widely anticipated, especially among online gun rights activists. They've always looked at Chevron as a kind of something that empowers the ATF to make a lot of rules and avoid, I guess, scrutiny from the courts. This is the sort of reputation that Chevron has. And I think it's certainly true in some regulatory areas with a lot of federal agencies. But I've always thought it wasn't really the case in gun law with the ATF. A lot of these rules that have come out since, Trump dropped the bump stock ban and then Biden has done 4 or 5 rules that kind of double down on that model, the pistol brace ban, the ghost gun kit ban, the reclassification of who needs to get a license to sell used guns, all that stuff. There've been court cases over all of that, and Chevron has not really been an issue in this. And so Matt wrote a piece for us. And yeah, I think that was basically his take too. He did an analysis piece where, essentially Chevron being struck down probably isn't going to have a very significant impact on gun litigation. Right.
Yeah, I know that's something we kind of talked about a little bit last episode, just in our immediate reactions of Chevron coming down. And it's interesting to hear from, Matt's take as someone who actually practices in this area, saying something similar, where it's not going to be some earth shattering, suddenly the ATF is vanquished in court or anything like that, because it's, Chevron wasn't really super involved in a lot of these latest cases. And it's not typically applied to these gun regulations with criminal penalties, which is a lot of what we cover here with the bump stock ban and the pistol brace and all this stuff that carries severe criminal penalties. So It's not that there's going to be suddenly their secret weapon is taken away and now it's an easy win for gun rights advocates. And I don't really think that's going to be the case, and Matt doesn't seem to think that's going to be the case either. But at the same time,
and Matt has been involved recently in a case of the auto key card case. So there are ways to make semi-automatic firearms into fully automatic firearms. And then we're not talking about like bump stocks where you're still using the mechanics of a semi-automatic and you're just pulling the trigger or actuating the trigger much, much faster than you would with regular shooting techniques. But, this is more like a Glock switch is probably the most famous version of this that people have heard of at this point, where you're actually transforming the mechanics of the firearm by adding pieces to make it capable of full automatic fire. And so there's a thing called an auto key, which you can do this in, AR-15s that are properly equipped with the right internals. You can add, an auto sear, there's drop-in auto sears. There's different mechanical ways you can change a gun from semi-automatic to fully automatic. And they're illegal. And that's, under the National Firearms Act, unless you can buy drop-in auto sears that are registered and legal to own. But, he's dealing with a case that involves someone selling a card that has like an outline of what an auto key looks like, as a sort of political protest that says, don't make this, but here's what it looks like, and sort of a philosophical political protest of the regulations and a critique of them, essentially. But he's been the guy who was making and selling these has been brought up on charges by the ATF for violating, their interpretation of the federal law underlying that, the National Firearms Act. And so Matt has been directly dealing with a case that speaks to this kind of thing. It deals with the ATF's interpretation of what's going on with these auto key card. They're not milled out to actually be something you can put into a gun. They're just like the size of a card. And maybe we'll have Matt on at some point to talk about the details of that case. But it does deal with this question of like the ATF's interpretation of this product being covered by the National Firearms Act. And obviously, Matt and his client disagree with their interpretation to that end. And, so he's been fighting this in court for a while now. And yeah, I think it's a similar situation. So he's somebody who has a direct experience with this exact kind of fight. And yeah, he essentially argues that this just doesn't have any bearing, the Chevron deference, not legally, on these sort of cases. And we've seen that ourselves with our reporting. And it's generally because of this concept in criminal law. Chevron has much more to do with civil penalties levied by agencies against companies, right? And oftentimes in gun law, the punishments aren't civil, they're criminal.
Right.
And there's a concept that we've talked about before on the show that has come up in a number of these ATF rule cases that we've covered, but it's called the rule of lenity, where if a law is vague or confusing, or the government's interpretation of it has led to confusion or could reasonably be viewed that way, then the defendant gets the presumption in that case. And so this has come up with, the bump stock ban, the ghost gun kit ban, the pistol brace ban, because the ATF had different positions on all these things over the years. And so the courts have at least oftentimes interpreted in favor of the defendants in those situations, or the adversaries, for whether the plaintiffs or defendants, against the ATF. And that's what often makes Chevron not really applicable in these cases. Although, he did have an interesting take at the end, I thought, right? Because he talks about how, while it may not have been they may not be appealing to the legal principle at play in Chevron, sort of the concept does come into some of these cases, right?
Yeah. This is essentially with the commentary you've seen around Chevron sort of writ large, not just in the gun context, but these agencies are still going to get some deference, if not, a de facto Chevron deference, but some sort of deference, because they're perceived as experts. They still have technical, expertise in these realms that they're regulating, obviously. So in that sense, they'll still get some sort of deference, as, courts will rely on them as the experts in this field. There just won't be some formal doctrine anymore known as Chevron deference, no rule that says we have to, but in practice, It'll still work that way because they are, the experts in this realm. So.
Right. That's how a lot of courts perceive it. Right. And that's what Chevron was based on, was this concept that, the regulators are filled with experts in the topic. And so we should give them deference to, anytime that they make a determination on something. Yeah. And that's no longer a precedent that can be cited as like a legal concept, but it is still something that probably will play a role in these cases. Because, now basically courts will have to decide, instead of just defaulting to whatever the agency had previously said, they're going to have to decide who has the better argument. And that's still going to come to play. And that has been in play in these gun cases, to some degree at least, right? Even if it's not like a formal legal doctrine that they're citing. So, that's how maybe there's some impact by the court unabashedly, planting its flag. I think Gorsuch had a colorful metaphor about how, they're really telling you it's dead now. While they've been chipping away at it for a long time. They're officially saying, look, here's the tombstone you can point to for Chevron's deference. Maybe that has an impact on this more informal preference that courts have shown towards agency reasoning over the years. And that might have an effect in gun cases.
Yeah, we'll have to see. We'll stay on top of it as these cases play out. But listeners should definitely go check out that guest post, because it's definitely interesting. And then Last couple of links we want to hit before we wrap up here is 2 developments in some sort of novel California first of their kind gun laws. So this week, as of July 1st, 2 separate gun laws in California started to take effect. So the first is the merchant category code requirement for all gun retailers. Monday, July 1st was the deadline that every credit card payment or every credit card company in the state had to have that code available to give to banks. Banks don't yet have to assign them to gun purchases. I think that's not until next year that actually takes effect. But the codes themselves have to be made available by those credit card companies. And listeners may recall sort of the Sturm and Drang that's been going on because they announced that they were going to make these codes, and then there was backlash from gun rights advocates, and then these big credit card companies got scared and said they were pausing the codes. Well, now they're under a statutory obligation in the biggest state in the nation to actually come back out and have those codes. And I tried to reach out to these companies to see if they've complied with the law just yet, and no one's willing to talk to me. So I would assume that they're complying with the law, but we don't know that for a fact.
Yeah, they won't say, right? Maybe we'll get a statement after the holiday. I don't know. We'll certainly, if we hear anything, right, you'll do a piece on it. But it sure sounds like these companies are kind of caught between a rock and a hard place at this point, because you have a bunch of states that are saying you can't use these codes, and now you have on the flip side, you have states saying you have to use these codes, and they're often really large states where they have a lot of business. So California and Texas, I believe, have countervailing laws in this point, and so it's just going to make it an administrative mess for these companies, I imagine, and for we've talked about this before, but the practical implications of this are pretty minor. It's kind of your CSI thinking, like somebody who's watched too much TV police procedurals, where the sort of zoom in and enhance type of thinking that goes into this. Because the problem is, you can make a merchant category code. These are the things. This is how credit cards will offer you rewards based on the category of goods you spend it on, like airlines. Oh, if you spend money at an airline, we'll give you X amount of rewards. Okay, well, the way they determine that is because they have these codes for what the merchants are, what kind of merchants you're buying at. And that's how they tend to use them. The problem is, those codes don't give the credit card companies access to what you're actually buying at those merchants. They just know that you're buying from a merchant that does X kind of business. And so before now, gun stores had merchant category code. It just wasn't a very specific one. It was like sporting goods. It was in the sporting goods realm usually. And now they'll have a code for it, but you won't actually know what the credit card companies won't actually know. The processors won't know what you're buying from those gun stores, because the whole concept, this goes back to a New York Times piece from years ago, right? That was complaining about this trend among mass shooters where they would use credit cards to buy their guns and ammunition. There were a couple of high-profile incidents where that was the case, and so the theory was, if you could kind of develop a model for you look at all the spending that these mass shooters have done, because they tend to buy, a bunch of guns and ammunition in a very short period of time before they carry out their attack. And so the thought was, if we can create this profile of a mass shooter and then apply that to every purchase, I guess, in the country in a sort of Big Brother-esque attempt, or, look, they compare it to, there is some effort to do this with terrorism, or money laundering or things like that. They do try to use a sort of broad profile to try and flag potential criminal purchases or criminal transactions, right? It's something that already happens to some degree, but this concept was to develop a mass shooter profile, a spending profile, and then try to flag any transactions that match that, and then I guess send it to the police and they'll investigate it. That's what the concept is here. The big problem with that concept is, if I go buy a safe if I spend $5,000 at a gun store, it could mean anything. I could be buying one really high end gun, right? One super high end 1911, like a Nighthawk or a Cabot or something, crazy expensive. Or I could be buying a gun safe,
right?
That costs $5,000. Like there's just no, or I could be buying a bunch of ancillary stuff that isn't even guns or ammo. Gun stores sell all kinds of stuff. And there's no insight into that with the merchant category code. You need a much more detailed, they call it basket level view of what's being bought. And that's what, like, your bank might have access to that, but not your credit card processor that issues these codes. So even in the scenario where they make this code, it doesn't do what the advocates want it to do. And then even in a scenario where you just say, all right, well, we'll just be very broad about it and say anyone who buys $5,000 worth of stuff from a gun store will send that as a flag to the police. Well, you're just going to get a bunch of false report. Like, you're just going to overwhelm police with a bunch of really useless information, frankly. You'd have to have a very specific profile. You'd have to know that it actually applies to people who carry out the kind of mass shootings that you're worried about, and not to everybody else who doesn't. And it just, they haven't really gotten that far in any of these conversations or thoughts about this. It just became a political thing to do, as something the finance industry should be doing to try and help combat mass shootings that no one seems to have thought very far into. But anyway, it's put these companies in this unenviable situation where states are both forcing them to adopt these codes and forcing them not to adopt them. And they're kind of the hot potato in a political fight now.
Right. Especially, like you said, the biggest markets on either side are doing it because California has it now. Texas and Florida have both banned them. And then New York just passed a law to mandate them. So literally the four biggest states, two on either side, are kind of splitting them apart at the seams. And that could be why they're hesitant to say anything about it. But
of course, they don't want to talk about it.
We'll update listeners if they do decide to make a comment one way or the other about this development, because like you said, even though it's not a really workable policy solution, it has become a salient political issue that separates these states. And it's one of the biggest trends in gun politics at the moment. So we'll certainly be staying on top of it as it develops. Then the other big California news this week was another one of their first in the nation laws that took effect is their state excise tax on all gun and ammunition sales. So as of Monday, July 1st again, all gun and ammo sales in California will be tagged with a 11% tax in addition to the federal 11% Pittman-Robertson tax. But unlike that federal tax, which goes to conservation efforts, this state tax is supposed to fund gun violence prevention services and crime victim remediation kind of services. But it's going to be funded on the back of gun and ammo purchases. And that's the first state to do so, but it's might not be the last.
Yeah, I'm interested in where this all ends up in court, because I do, Rahimi certainly raises some more questions about the Bruin test, as Thomas pointed out, right? And we do have gun taxes or gun-related taxes. Pittman-Robertson, like you mentioned, the National Firearms Act is actually a tax on certain kinds of guns. That's one of the reasons, like, some of these attempts to subvert the NFA, but you've had a couple of states where it was like, oh, it's legal for you to make and own suppressors and sell them as long as it's all done within our state. Texas has tried this. I think it was Kansas tried it first, to disastrous results where people ended up being charged with felonies because they actually believed their lawmakers on that point. And it's not true, because they sort of assume the problem is that the Commerce Clause overreach, which is a common complaint in conservative circles, but that's not actually how the NFA is justified. It's a tax. It's a tax on guns. It's one that I think nobody on either side takes seriously as a tax, because everybody understands that its actual purpose is to ban or severely restrict certain kinds of firearms, not to tax people. because just look at the pistol brace ban, right? That was an attempt to severely restrict or ban new sales of pistol brace equipped firearms by making them subject to the National Firearms Act, which is a tax. The registry for the National Firearms Act is just proof that you paid the tax. So that's what it's supposed to be. But when they did the pistol brace ban, they waived the tax and still made you register. So you proved that you paid the tax that you didn't actually have to pay. But regardless, it is a gun tax. It's only dates back to 1934, of course, but I think the bump stock ban case, while not a Second Amendment challenge of the National Firearms Act, does give a lot of insight into what the justices think of the National Firearms Act, which is that they sure seem entirely comfortable with it. And while they struck down the bump stock ban, the Alito's big way to explain this action was to say that Congress should have just made bump stocks part of the NFA. So, if you look at that case, it's not a case where they're skeptical at all about the national firearms, its tax, or its restrictions on certain types of firearms. So, I don't know. I mean, I don't know how they handled taxing firearms at the founding. I'd be interested to find out more about that, but I'd also be interested. I'm also curious about the practical side of a challenge to a gun tax like this, even though it's a brand new thing that's never this sort of gun tax. I don't think has ever been done before. Like San Diego tried it, and yet you would think that would make it a pretty prime target for Bruin. But you look at sort of the practical implications of some of these rulings and where some of these justices come down, and I do wonder how that's going to shake out in the end.
We'll get a test case because a big coalition of gun rights groups just announced a new lawsuit against this California tax. So the California Rifle Pistol Association, the NRA, FPC, and the Second Amendment Foundation, all of them together joined to sue this. So we'll see how that lawsuit plays out, because it is sort of a novel issue, and it could take on bigger meaning because Colorado is looking to adopt something very similar. All it will take is a vote of the people this November. It already cleared the state house and the governor signed it, and it just needs a vote of the people. And Colorado will be right there in that same boat too. So this could be something that has a little bit of a longer reach.
Yeah. What historical tradition does this fall under, and how does it interact with the government's taxing power? Right. I don't know.
It's an interesting one that's worth watching. That's for sure.
Yeah, we will see. But, yeah, is that all we got in terms of stories? I mean, it's a pretty short week this week, right?
Yeah.
I think we will have another piece from Robert Leiter, professor, coming up soon, analysis piece on that's pretty interesting. On there was an SEC case that basically eliminates the ability of federal agencies to kind of hold their own sort of mock trial system and fine people substantial amounts without going to a jury, going to court. And that actually seems like it may have implications for, of all things, the TSA and how it handles people who accidentally bring guns through the security line. And that actually has taken on a bit more salience this week because we had a Republican congresswoman accidentally do that on a trip to Europe. She apparently was caught with a unloaded gun in her bag, which she had said she'd forgotten, which I think is very believable because that tends to happen quite a lot in this country. It's kind of funny. It's like one of the things that the TSA is constantly blaring out, that they've stopped X number of people from bringing a gun on the plane, but they never mention like that any of these people were actually intended to try to do that, or
right.
Because I think that 99.9% of those cases are likely people who accidentally did. This happens in Congress sometimes as well. A staffer comes in from Virginia and they forgot they left their carry gun in their bag and try to bring it in, and everyone acts like it's like a big security story when it's almost certainly not.
Right.
And it happens with, you hear this about football players every so often, right? Like a football player will accidentally bring their gun and try to get on the plane. because they forgot they had it and so. So, it's like, no, I don't think those people are trying to hijack the planes. And if they are, you should lead with that evidence that you found, because it always seems like a security theater thing to me. Like, oh, wow, TSA, we caught 500 people trying to bring a gun through security over the last several years or whatever, and like we're so good at our jobs. And it's like, okay, like I'm glad that you did catch the gun, but I don't think you're actually stopping real threats here. Like, you got to give me something more than just they had a gun in their bag. Like, was there some sort of criminal intent going on? Anyway, the SEC ruling, you might not expect that to have an impact on gun regulations, but it seems like it could. And so we'll have a piece from Professor Leiter on that, and that'll be out relatively soon. And I think people should look forward to that one. But otherwise, you're going away for the 4th, right?
Yeah, right after we finish recording here, I got to head out and go meet some friends for a camping trip over the 4th of July weekend. So I'm looking forward to that.
Yeah, I think I'm just going to a cookout with some friends locally. So I hope it's supposed to thunderstorm here in Virginia. So we'll see. We'll see how that works out with the fireworks. Hopefully, it doesn't ruin everything. But, it's been getting fireworks all around for several days now, as people are wont to do.
Yeah.
Which is fine with me. I like fireworks, but although I did just go to the range last weekend with my girlfriend and some friends and had a good time there. So did my patriotic duty, I guess, to go to the range before the celebration of Independence Day. And maybe I'll go again this weekend. I don't know. Why not? Right. I had a good time. I still want to get more time in with that red dot. Switching from iron sights to red dots red dots are definitely superior in my estimation, but it's a different style of shooting. You have to,
takes practice.
Yeah. Both eyes open, focused on the target, and then put the dot where you want it to be, but it shouldn't be what you're focused on. Whereas with iron sights, you got to focus on that front sight if you want to be accurate. So totally different sort of mental process to it. But I really think it's absolutely worth the improvement. And that's where the whole industry is going. You can see if you walk into any gun store, and I think it's for good reason. So, but that's all I've got, I think, right? You got anything else?
I think that's it for us this week. Happy 4th,
well,
everybody.
Have a good time on your trip. And, let's head to our message from the Dispatch. You could celebrate Independence Day by signing up for an independent publication, another one. They give you a free trial for 30 days too. Let's hear about that. That's right. This episode is brought to you by the Dispatch. We're doing one of these classic promo swaps with them, actually on Kevin Williamson's newsletter, which is one that I personally subscribe to and read pretty much every time it comes out. I've actually been a paying subscriber to the Dispatch since they launched. They have over 400,000 readers now. Jonah Goldberg and Steve Hayes and Chris Steyerwalt and Ala Pundin. There's so many people who write over there that I've long followed and respected and enjoyed their perspective. And of course, in addition to a lot of the great commentary that they have from people that you probably know better than me, the people who are more well-known than I, they also have a lot of really deep and original news reporting that they do. And so that's why I've been happy to have them as one of our sponsors, as a promo swap. I definitely stand behind their work and recommend it to you guys in a way that I couldn't say for a lot of other publications out there. So, if you're interested in checking out the Dispatch, if you haven't heard of it before, or you haven't taken the time to go over and examine what they're bringing into the world from a journalistic standpoint, I think you should do it. And in fact, part of our promo swap includes a 30-day free trial for their paid version. So you'll get access to everything they have for free for 30 days. So you can read it and make up your own mind. Just follow the link in the description here or in our newsletter this week at The Reload. So that honestly, I just do legitimately recommend them. And so I'm glad to do this sort of promo swap because they're one of my favorite publications, and I think you guys will enjoy them if you enjoy what we do here at The Reload. So check out the Dispatch today at the link in our description.